guys, and good evening. And I will continue to check the sound if you guys let me know if any issues with that. So what I'm going to look at here in just a minute is the motion for protective order that the state filed. And we'll get into why they did it. I think it's shown up on some of the Law and Crime and Court TV stuff already, but we'll go over kind of most of, if not all of the document, because there are some particulars in it that are interesting. But it certainly has a little bit of a bombshellish kind of situation going on here. And to me anyway, not something I didn't expect, but just to finally see it in writing at least. So this is going to relate to this K-bar knife thing. And I did a short video on this a long time ago where they were talking about they were looking for a K-bar knife, and I think you could show knives on this stuff. So anyway, only thing really distinctive about it, a knife like this, is the pommel and the hand guard here. Other than that, it's not really different. What I wasn't thinking about, but I should have, is that they had that classic leather sheath available. But I don't have that on the K-bars I have. I have the more modern sheaths. So that's what they found at the crime scene, right? They found the sheath for the knife, and they found DNA on it, a single source DNA. And I think they said it was on the snap. I don't think they say that in this motion, but I have read that before. So, oops, you don't want to drop that at the crime scene. It's not exactly the murder weapon like we talked about in the poll that we'll go over later in the week, but it's what the murder weapon came in. All right. So let's get this document rolling here. There we go. All right. So this is a motion for protective order that the state is filing because they don't want to give certain information to the defense. And that information is related to the genealogical research that they, or the FBI and other people, did to try and figure out whose DNA, or at least narrow down the pool of people related to the DNA found at the crime scene on the knife sheath. So they don't want to turn that over. They say those people are not related to this situation at all, and it isn't relevant for Kohberger because it's not exculpatory evidence, since it does lead to his family, and it's not going to be presented at trial as evidence because they have a direct comparison to his DNA to that found on the sheath now. And that's what matters, right? Not whether somebody he's related to, or potentially him, somebody in his family tree, had this knife, but whether he did or not. Okay. So let's hit this. So they are saying, and of course it arises from quadruple homicide. Sorry, I'll have to go through some of this language to get to what we need to look at. So law enforcement found the DNA of a potential suspect at the crime scene, and the FBI submitted the DNA to one or more publicly available genealogy services to determine potential relatives of the suspect. And they get into some details in this, kind of interesting, in a few minutes. They developed a family tree, and the state wants to protect from disclosure of the names and personal information of the hundreds of innocent relatives on a family tree. And the services and other information described below, the defense want to get at that. And I don't blame them, because when you find out how they tested his DNA to the knife and what the odds are that it's anybody other than him, you got to look for something, right? So it doesn't look good for him. And that's because he's the guy who did it. All right. So that's my opinion. And they say they shouldn't have to disclose this information. And I'll show you their logic, and you can agree or not, be up to the judge to make that decision. So on November 13th, law enforcement found the bodies of Madison, Kaylee, and Xana and Ethan at the King Road house, as we all know, and they died from knife wounds, apparently. They found a K-bar knife sheath on the bed next to the bodies of Madison and Kaylee, and it was face down, the sheath, and partially under Madison's body and the comforter on the bed. So that, as you know, that if it does for you like it did to me, kind of set your imagination on fire there a little bit. Like how did it get like that? And so at some point it landed on the bed, and then she and the comforter ended up over top of it for the most part. That could be, in a struggle, and other people around and stuff like this may be why he neglected to take it with him, didn't notice it or whatever. I've never gone to anybody's house and stabbed 4 people to death. I imagine that can be pretty stressful on the murderer, and you may not do everything perfectly. And in this case, he did not, and he left this at the scene. So that's bad news for him. And yeah, I was about to respond to this, but I'm not going to, because somebody made the point that they listen to this rather than watch it sometimes. And if I'm not telling what the quote is, or the question is, then how do they know what I'm talking about? And I do that on YouTube a lot too. I just listen to it. So as he's butchering that victim, this comment says he isn't thinking about the sheath, but he's ready to move on to kill the next one and not put the knife away. And I think that's right. Now I don't, know where he had the sheath at, why he even brought it into the house with him or whatever, but he did, and it was in there and he dropped it. So bad news for the murderer, I think. And this says, I hope I didn't miss much, just the new countdown thing I tried out, and we're just getting into it now. So, all right. So again, they found this evidence under the body of Madison and the comforter on her bed. So every once in a while you get this eagle of innocence scenario of like, oh, maybe, somebody dropped it there while they're at the party or whatever. I think this pretty much puts that to bed, right? It's found under the murder victim on her bed. Yeah, this is the knife, the container for the knife that was brought to the scene for these murders. I mean, come on. So I haven't seen anybody say that here. So this chat is people of great intellect and great judgment. So thank you for that. All right, let's move on with the show here. They seized the sheath, of course, naturally. And the Idaho State Police Lab located DNA on the sheath, and they determined the DNA came from a single source that was male. Once they had that, they conducted a short tandem repeat analysis. And I won't even try to tell you that I know how to do all this DNA stuff, but they're going to explain it to some degree. That involves looking at 20 regions within human DNA and allows direct comparison between DNA profiles. So they create at the state lab here, right, this STR analysis. And they put it in CODIS, and I don't think, they didn't find anything there. And that's the first thing you would do, right? See if that's somebody's already been in the system. So then they decided, well, let's do investigative genetic genealogy to find a lead. And you're trying to find the family tree there, right? And that could provide a lead for you. It's not going to tell you necessarily who did it, but it will provide a lead. And they talk a little bit about how that works. And they create a different kind of profile called an SNP profile. And they use an algorithm, like everything on this planet now, to compare the user's SNP profile to the other one submitted to the service. And, depending on how it goes, you can find out lots of information, as they did in this case. And people in the public do it. This will be important later because, of course, you can imagine that the defense doesn't want this evidence in, and they're going to make all kinds of arguments about it, which they should. That's their job. It doesn't mean that it should be successful, of course. And it can narrow a person down. And furthermore, if you got location, gender, age, and things like that, you can start to hone in on things. And of course, this kind of investigative technique has been used to develop leads that have solved other cases. All right, let's see. In this case, they began the process of developing a lead to the individual who left the DNA on the K-bar sheath. They sent it to a private laboratory to develop the SNP profile from the DNA. That's the one you use when you're going to put it in there and see who you're related to or whatever. They already did their own STR profile. The private lab started using genetic genealogy to develop a family tree, but the FBI stepped in and took over. The private laboratory ceased what they were doing and sent it all over to the FBI. And the FBI started working on it, right? And skip down through this a little bit, but they're building a family tree. It also says they use the same tools and methods the FBI does. The members of the public who wish to learn more about their ancestors would use. They consulted social media, viewed vital records, birth and death certificates, and other information already contained in the user portal for genetic genealogy service. And then they also use their own private subscription stuff. And they got hundreds of relatives and eventually developed a connection that, based on their analysis, said, you guys should check out this Bryan Kohberger dude. So the FBI sends to local law enforcement a tip to investigate him. Now, this becomes an important point later on in the legal argument. The genetic genealogy process pointed law enforcement toward defendant. This is the state talking here. It did not provide law enforcement with substantive evidence of guilt. Okay, this goes pretty much right to the heart, and I didn't know this was coming out at the time I wrote that poll, but this family connection is not substantive evidence of guilt, the state is saying. It says the FBI did not conduct a direct comparison between the S&P profile from the K-bar knife and Bryan Kohberger's profile. There was no direct connection there. And they would use the more traditional STR DNA analysis, and that was done by Idaho State Police, not FBI. All right, they repeat again here that before the FBI got going, the state had already done its own analysis and developed the STR profile, and that's the one you would use once you finally have somebody in your sights as a suspect. After they identified Bryan Kohberger as somebody who they needed to check out, they recovered trash from the home of his parents, and of course they did STR DNA analysis of items from the trash for comparison to the example they had from the crime scene. That indicated that the DNA found on the trash belonged to the biological father of the individual who left the DNA on the sheath. And I think we already knew that from the probable cause affidavit, but what we're learning from this is a little broader picture of how they did this. You know, the FBI stepped in and did this whole family tree thing and worked on it, and then they think, well, this might be the guy right here, and then they actually get some trash from the house and compare it. So now you're not working off a database anymore, you're working from something you got, and they think that's the father. So now it's all tightening around Kohberger, even though he stands in the kitchen at 2 a.m. with gloves on and bagging his trash individually and putting it out in his neighbor's garbage can. That's great, except for the fact that he left DNA at the scene, and law enforcement is working to solve this murder, and putting it all in a baggie isn't going to keep them from doing it. All right. So after that, of course, you know, he's arrested, and an earlier video and other people have shown too, they got a search warrant to do various things. And one of the search warrant items was they can get his personal DNA sample. And they did that. And I'll come back to some of these comments in a minute and get through some of these arguments here. I'm a one-track person at this stage. And anyway, so the traditional STR DNA comparison was done between the profile on the knife sheath and Bryan Kohberger's DNA. Okay. So they have now compared the DNA found at the scene to Kohberger himself, because there were some people who were like, well, the family connection isn't very tight and that doesn't prove anything. Well, the state says here, no, it doesn't prove anything. It's just an investigation technique like other tips and leads to get to the point where we actually are trying to get evidence that will prove what we're trying to show, which is that he committed the murders. And is that DNA evidence direct or circumstantial? Will the state tell us in this and ruin the Friday show? We'll see. The comparison showed a match. Specifically, the STR profile is at least 5.37 octillion times more likely to be seen if Kohberger is the source than an unrelated individual randomly selected from the general population. In other words, I think that means as far as DNA can take you, the person's DNA on that sheath, that's Kohberger, right? To beyond any reasonable doubt. So however it got there, whatever you choose to believe, that he dropped it or Eagle or somebody bought it at the flea market, you know, whatever, it's there at the crime scene and his DNA is on it. That's him. So you can drop out this whole, and basically this is what the state is saying. You can just forget this whole family thing from this point forward, because we've done what we should do, which is connect his DNA or test his DNA against it. Because what if it was one of his relatives? He would have come back not a match. But since he is a direct match for the DNA found on the sheath, the other stuff doesn't matter anymore. All right. So, and that's what they say here. The research conducted by the FBI resulted in a lead that pointed law enforcement to defendant, but it did not result in the creation of any documents or records, they say. They were just working through the user portal, trying to figure this stuff out. They didn't download or create copies of it. Once they had Kohberger in custody, the FBI removed the S&P profile from the genetic services because they have a policy for that. The United States Department of Justice interim policy for forensic genetic genealogical DNA analysis and searching. That's part of the Paperwork Reduction Act, I'm sure, to have a title that short. This means the FBI no longer has access to view much of the information it used to create the family tree, and it cannot view it again unless they put all that profile up there and stuff. And then there's just some notes and things about it. And the reason is, again, they just were working on the lead. So now they have an actual comparison of his DNA that they got from the search warrant and they compared it to what was found at the crime scene, and they have this, what you would want, which is, okay, is it his DNA or not somebody from his family? So they have the evidence now. So the state wants a protective order for a narrow category of information, namely information related to the use of this, this family genealogy research. And they go through the Idaho rules, and because of course, if they have exculpatory evidence, they're supposed to turn it over to them. And then there's other things they have to give them too through discovery. And the defense has been very active in this case, requesting discovery, and they should be. It's not bad for his defense attorneys to do their job and put the state to the test. That doesn't mean that they're right about everything that they're asking for or saying, though. All right, so they say the state will provide three discrete categories of information: material information that would tend to negate the guilt of the accused. And since this was within his family, it doesn't do that, right? It doesn't prove it's him either, but it certainly doesn't help show it's not him when it's inside of his family. Any documents or objects that are material to the preparation of the defense are intended for use by the prosecutor as evidence in trial, or that were obtained from the defendant or belong to the defendant. Reports of scientific tests or experiments. And we'll see what they say here. So the state wants to protect a narrow group of information here: the raw data related to the S&P profile and the underlying laboratory documentation, chain of custody forms and things like that. They don't want to turn that over. The family tree stuff, potential relatives and things. They do not seek to protect, and they have already or will disclose all of this following information, and this is important: a genotype kit report from the private lab utilized by the Idaho State Police, which documents that a DNA test was performed; information related to the STR DNA analysis conducted using the DNA recovered from the sheath and DNA recovered from the defendant's parents' trash; and then also the STR DNA analysis that directly compares to Kohberger's sample that he gave pursuant to the search warrant. So what they're saying is, look, all the information that directly relates to whether this is his DNA or not, him personally, you get it all. You get all of that. What we don't want is be turned over any list of relatives and things like that who have nothing to do with this crime because it's his DNA. And they're saying that, you don't have to turn this over because it does not tend to negate the guilt or reduce punishment. Certainly it doesn't in this case. And I think that, what the defense would want to do with this is try and say, oh, well, you violated this right or that right, or look at this form you did wrong when you were. But what the state is saying is, listen, none of that stuff about whether forms were right or not, it's not even relevant here because this isn't evidence we're going to use. The part about it being his family's DNA. The evidence will be the comparison of his DNA to the sheath. So if you have issues with that, certainly bring those up. But we don't have to, drag his whole family into this. And they have a case on this, which we'll get to. And they say here, which is, I'm going to stop here because I see this a lot in Idaho. The question of whether this information must be disclosed as exculpatory is one of first impression in Idaho. A lot of things are, because Idaho doesn't have a lot of law. Surprisingly, Virginia doesn't either. So they're often looking to other states for guidance, even though it's not, they don't have to listen to other states. So you'll see lawyers try and find anything they can to use the reasoning of other courts from other states as persuasive to guide what they should do inside of Idaho. And they say, look at this case here in California, where the court said, no, you shouldn't do it. And in that case, law enforcement used DNA recovered from the victim's nightgown to identify the defendant as a possible suspect. But then they recovered items from his garbage that contained his DNA personally, and then they directly compared that to the DNA found on the nightgown and saw that matched. So they had a big fight about it, and the court said the evidence that is material to the defendant's guilt or innocence is the testing that followed the family genealogical investigation, which directly compared a fresh swab of the defendant's DNA with a DNA profile collected from the nightgown. It's only this evidence that the people intend to present at trial. The people are not obligated to provide preliminary search of the genealogy databases for possible matches. That's investigatory in nature. It's not exculpatory or material to the defendant's defense. And so that's the state's argument here too. And they're saying, a court already considered it in California, and it was a layup to say that, yes, you get everything related to testing his DNA against the DNA that's going to be used in trial that was found at the crime scene, but just figuring out what family he belonged to is not part of that, because now we have the more direct evidence of the situation. Right. So I'm going to pick a comment out here just because I happen to see it. And we'll read it. It seems like covering up Kohberger's family tree helps them and him, not the state's case. Well, yeah, it does in terms of the comment you made right after that, which is, oh, yes, here's the Kohberger gang's name, addresses, phone numbers, paparazzi have at them. You know, there's some reports that his sisters have lost their jobs and stuff like that. And there's no indication they had anything to do with anything ever. So if that's true, it's terrible. So the state is saying here, yeah, it's better for everybody, the family and stuff. If you don't turn that over, it's not relevant to his defense. Now, the defense wants it. And that's obviously not because they're going to go out and publish his family's information to anybody. But what they're looking for, anything in any part of the case where they can say the state messed up here. The state violated a right here. The state didn't follow this procedure here. That's what the defense is doing, which is what they're supposed to do. They're supposed to try and see if the state is able to prove its case inside the law. And they're being very aggressive about it, but it's a potential death penalty case, so that's okay. That's the job of it. And the state is saying, well, you know, if you find a thing like that in terms of how we got and used his DNA and the crime scene DNA, let's fight it out. But we don't need to bring his family stuff in because that's not going to be used in the case. And they say that here. The information is not material to the preparation of the defense. The defendant is charged with killing 4 people, not with being related to a particular person. The mere fact that loading his S&P profile up into a database led law enforcement to relatives of the defendant does not affect the strength of the evidence against him. Right. The strength of the evidence against defendant in terms of DNA depends on the confirmatory results from the STR DNA analysis the state lab did, directly comparing his profile to that recovered from the crime scene evidence item, the sheath. So the state says, look, we intend to introduce the STR DNA analysis at trial. In other words, his DNA compared to that on the sheath. We do not intend to enter any evidence pertaining to the development of the S&P profile or the family tree building process for inculpatory purposes. Not going to do it. The state has disclosed or will disclose the information it has related to the STR DNA analysis. So there you go, right? And they're saying it's immaterial. And here comes an analogy, because what kind of lawyer doesn't like to create an analogy? And I don't remember what it is, but let's see what it says. The tip that came from the family tree DNA process is no different than other type of technology hits that put law enforcement on the trail of a suspect. Here's an example where law enforcement recovered a suspect's DNA from a ball cap left at the scene of the bank robbery. They ran the profile through CODIS. It resulted in multiple hits, including the defendant. So it could have been one of several people. A scientist narrowed down the hits to the defendant. Law enforcement confirmed it was the defendant's DNA when they required an actual DNA sample from the defendant. And he said, look, I want to know everybody who it might have been before you actually compared my direct sample to what was found at the crime scene and not this other thing. Well, the court explained the DNA evidence that's material to the defense was the direct comparison between the DNA on the hat and the DNA taken directly from the defendant. The fact he was first identified as a possible suspect based on a database search simply does not matter. And, you know, if you want to see murderers run wild and free in the open fields and meadows, then you certainly want to exclude all evidence, right? But I personally agree with the logic they have here, which is his DNA sample compared to the crime DNA sample is what the state will use in a trial, and it's what the defense ought to be able to rebut. You know, whether there's a partial sample that points to some other family or something, I don't see that as being relevant, and the state doesn't hear it. And of course, the cases they cite don't either. I haven't read other stuff from the defense. They may have a case that says something different, of course. And they're going ahead and saying, listen, because they expect this argument, this information from the database could not support an argument from defendant that law enforcement violated his Fourth Amendment rights by entering the DNA that came off the sheath into the genealogy service. A defendant cannot prove a violation of Fourth Amendment without first showing he or she had a reasonable expectation of privacy in a place searched. The K-bar knife sheath was abandoned at the scene, as was the DNA inside it. Interesting, it says inside it. I thought it was on a snap, but I don't know. Defendant cannot show that he had a reasonable expectation of privacy in DNA left at the scene of a quadruple homicide or in the genetic information of his relatives. He doesn't own their DNA. especially because they voluntarily provided their own DNA to the service. And then they cite some cases for that, which makes sense to me. And they're also saying the sheath and the defendant's DNA left on the sheath were seized pursuant to a valid search warrant. So not only they're saying did he have no expectation of privacy and the piece of the murder weapon he left behind, and that makes sense to me. Hey, that's my sheath I left at the murder scene. You can't look at that. They're also saying they had a search warrant to get it too. And when you have a search warrant, the burden of proof is on the defendant to show it was invalid, which you can bet they'll try to do. Now, they're also saying this family connection was not relied on by the state to establish probable cause for his arrest. They didn't present it to the grand jury. That's interesting, isn't it? I didn't know that. I doubt there was any way we could have known that ahead of time. See, I thought it was part of the probable cause for his arrest, but now that I'm thinking about it, they did mention, I think they had this family connection from trash at the scene. So they did all this very quickly. So the family match based on the STR strand, I think, is what was in the PCA and not this family tree thing. So they're saying that we didn't use it for his arrest. We didn't show it to the grand jury, and no plan to present it, the information for which a protective order is sought, as evidence at trial. Instead, we're going to rely on and continue to rely on the STR DNA analysis, comparing his DNA to that found on the sheath to establish his guilt. Direct or circumstantial? Again, we've disclosed it, or already have disclosed it, they say. I think that's the third time, at least, in scanning through this, that they say that we're not hiding the DNA evidence from the defense. We're providing everything related to testing his DNA against that found at the crime scene. The tangible objects and documents encompassed in the genealogy information were not obtained from Kohberger, and he has no property interest in them. That's true. To the extent the DNA on the knife sheath once belonged to him, he abandoned that DNA when he left it at the crime scene of a quadruple homicide. Really dunking there on that point, which I think is very fair. And something barking very loud outside. And they say it's not that what they got from the family is not the result of a scientific test or experiment. Okay. I hear them on that. I'm going to skip down through this because they're saying they had to look at social media and all that stuff. So here's a question. Has Kohberger been required to submit a DNA sample? And the answer to that is yes. One of the search warrants required him to submit it, and they did obtain a sample from him. And they say that in here. They were able to swab a sample, and it's that sample that they compared to the sheath. So there were 3 times the DNA came into play. The first was a different type of profile that they used for this family tree stuff that the FBI used to develop a tip for him. Then there was a comparison between the type of profile they'll actually use at trial and his family's trash that showed that it was a high likelihood that the trash they found at the house of his parents, that was the father of the person who left the DNA on the sheath. Then finally, the most important one, the one that really matters, is they did a direct comparison between his DNA and that found on the sheath. And that was the 1 in 5 octillion or whatever chances it's somebody other than him. So it's his DNA, right? And I mean, unless they can show that the lab had a contaminated source or something like that, the math indicates it's his DNA. And so they're saying that this family tree that the FBI did, it cannot be described as the results or reports of scientific tests or experiments, because it was really just a summary of investigation they did. Maybe so. I don't think it hurts the state if they have to turn all this stuff over, but I appreciate that they're trying to protect it, because really, what does it got to do with the case other than the defense fishing for some kind of issue in terms of how they collected it or something like that? Because now that they've matched it to him, what's really the point in worrying about upstream stuff? He's over the waterfall now. So the mere fact that this information does not fall within Rule 16 is reason enough for the court to enter the protective order. But they're not doing it just to be obstinate. That's good. I didn't think you were. They seek to protect hundreds of innocent civilians from having their personal information, including their names, birth dates, familial connections to the defendant in a high-profile quadruple homicide, from being disclosed. I would expect the defense to say to that, Well, okay, but we're willing to have all that sealed and just us look at it like we've done for almost everything else in this case. It risks harm not only to these indirect informants, but also to the services used by the FBI. What? Can you imagine some people on the internet harassing companies or people? That seems far-fetched, doesn't it? And then they talk about what the Idaho Supreme Court has said about things. Disclosure must not be required of an informant's identity unless the informant is being produced as a witness at a hearing or trial. And they're saying that the people who submitted the stuff up to the services that they use for comparison are indirect informants. So that's a good argument. They have no intent of presenting the information for which a protective order is sought as evidence at trial. So none of these informants will be produced as witnesses at trial. And the state has a privilege to refuse to disclose the identity of a person who has furnished information relating to or assisting in an investigation of a possible violation of a law to a law enforcement officer. And we like to protect the identity of informants, quoting some Supreme Court stuff. Wide discretion. And conclusion. Based on the above, the state respectfully prays for the court to enter a protective order protecting this genealogy research from disclosure as it falls outside the purview of Rule 16. In the alternative, if the defense can say in some way that's relevant, the state asks this court to conduct the requisite in-camera hearing. In-camera just means with the judge, not out in a regular courtroom where people could hear it, for the state to present information related to it and then enter a protective order. So it wouldn't be subject to discovery, need not be disclosed by the state. Well, it doesn't say ex parte, but it does say in camera. So anyway, so that's the state's argument here. So I think the bombshell aspect of that to me was the fact that they confirmed that they tested his search warrant obtained sample of DNA to the DNA that was found on the knife. And the quality of the sample on the knife must have been quite high because they said it was like 1 in 5 octillion, million, octillion, billion, whatever these numbers are, chance that it was somebody other than him. So if you believe DNA can match somebody, then you believe that it's his DNA on the knife. So let's see what people have had to say about it. I'll walk through this some. And congratulations to Vicky, because it's telling me that you're a new member. I don't know if you post that or it just does it automatically, because I also got this one. Another person whose taste I greatly admire. All right, let's see what another comment here. It's really sad. I thought they found this information that it had his DNA on it when they arrested him. So, okay, so you'll be watching this at 1 a.m. So by the time I'm reading your comment, you will already know the answer to this and know that they had tested it, I think, to his father's level, but not to him. But after the arrest, they had his DNA from a search warrant and they compared it and they declare it a match at a high degree of confidence. And the next one, this is floating around here. Why did he choose to stand silent on his plea? Because weren't these results in? State yet to find them. I think I talked about that a little bit in the chat. So I heard them say this because, it's kind of a bizarre thing. So he didn't say I'm not guilty. He just stood there, and under their law, that's the same as saying you're not guilty, the way they interpret it. Now, his lawyer later explained in a different hearing that the reason he did that was because there's some obscure case law, potentially, that if you stood up and said you're not guilty, that you're implicitly accepting the fact that the grand jury indictment itself is valid. Not that you agree with it, but just that it's valid. And they didn't want there to be any chance that they're waiving their dispute over the validity of the grand jury indictment because the defense is attacking that. So they say that's why they had him stand silent. I take them at their word on that. That was a legal thing. I'm sure he would have been glad to stand up and say not guilty. I will say when he's been in court and he's been asked to answer things, he talks clearly to the judge and gives brief answers that are directly to the point. He's not a dumb guy. And he hasn't wanted to be uncooperative while he's in the courtroom. So I think he would have been glad to stand up and say not guilty because he's had people on his side trying to say that for him, although apparently perhaps not even his own family. And we've got a new member here. Awesome. Let's see if this journey is worth it for all of us. There's something I wrote. I won't repeat it. And Marcia Lynn can't make it this evening, but maybe she'll watch it later and see that we did this shout out. Here's another new member. They're just floating in. I got my work cut out for me. All right. So few may agree with me, but I think there's a possibility that Bryan Kohberger was not the sole person who committed the murders. When he was arrested, he asked if anyone else was arrested. Yeah, well, okay. I mean, that's a fair point, right? We don't know that for sure. I think he was the only person in the house. That's what I think. And I think at the time he was arrested, perhaps he was concerned that, knowing like he does how the law is, that if the police were highly aggressive, it's possible they could have arrested someone else in his family, even if they shouldn't have. But they didn't, right? And it's also possible that he said that to throw them off. I've personally seen that happen. And but it is within the realm of possibility that, that somebody was involved with him in some way. I don't think he needed anybody else to commit these murders. While I don't know that he planned to murder 4 people that night, I suspect he's the one who did it, and he was by himself. But I wasn't there. I don't know that. So I take your point there. But he was there. That's my opinion on that. I'm pretty strong about that. They have video of his car leaving where he lives before the murders, coming back after the murders. His phone turns off. His knife sheath is found there with his DNA on it. I think we can all have confidence that they're going to be able to prove he purchased that kind of knife. It's not the same one. Everybody else buys it. I got 3 K-bars on the desk. None of them have the same kind of sheath that was found there. So that is what it is. And this says, sorry if I'm being stupid. I don't think you are, but what do you mean by not incidental to the crime? Well, I have to tell you that I can't remember what I said there. So if you remind me, I will try to answer it. And here's one. Most knife wares are not regulars, and sheaths are more show-off than part of a several times a day use items. It's likely you pulled the sheath away from him struggling with the victim. So it all depends. Usually when I carry a knife around town or whatever, I would have it in my pocket. But when I'm hiking, I certainly have one in a sheath. And when I was in the Army, I always did. But those sheaths are attached to things. When I hike, it's attached to the side of my pack. I keep a small knife up here. When we camped, a bigger stuff would be in the pack. And that's how it was in the Army too. Like I certainly wouldn't have been in a position to drop a sheath. Having said that, the K-bar, and if he's using a regular one, well, that's not small, is it? So the sheath is pretty large, and the whole contraption is pretty large. And, I guess he didn't want it swinging on his belt or whatever, which would be kind of dumb. So he must have been carrying it by hand, I would think, and then dropped it and didn't expect to drop it. But let that be a lesson. If you want to go in a house and stab 1 to 4 people, leave the sheath in your car, because you just don't need to. You don't need to occupy both hands when you're doing it. You gotta plan for the unexpected. And I think maybe he ran into some of that. I think maybe he ran into some unexpected things. All right, let's see. I don't think he did it all, and I'm not sure what that's referring to. And I think we talked about this before. As he's butchering the victim, he isn't thinking about a sheath. He's ready to move on and kill the next one. Not putting the knife away. Completely agree with that. Completely agree. And I got another member. Thank you. That's awesome. And some chats going on here. Countdown, great. Seeing if we got any questions about this topic. And so I'm thinking Bryan approached the victim on the bed without knife drawn, so his intent was potentially assault. Then he needs a knife and struggles to remove it. Anything's potentially true there. If I were imagining things and that's all it would be, I think he'd have it out, and maybe the sheath was in a pocket or something like that, and then it came out as the flailing begins, and it wasn't expected to come out. But it's possible. What you're saying is possible. Struggling means the victim is fighting back in my mind, and that's why he needs a knife immediately. Probably a new knife, a new sheath, too shiny new, like a little boy showing off new toys. Yeah, I don't know when he bought it, but I think there was some, the victims weren't all asleep, unfortunately, when he did what he did, and they were fighting back. I say it's unfortunate. If he got the result he got, then the fighting back that they did do and the struggle that they made and what they tried to do, in my mind, is likely why he dropped the sheath, because remember, this was found under one of the victims in her comforter. And that is going to solve this crime. Let's see. I'm late, but never late. Better late than never. And please hit the like button. I appreciate that. I will say about, I never say like and subscribe and stuff like that, but I do look at it in terms of, are people interested in hearing about this or not? So that helps me know. And if you dislike it, that lets me know that you hate it, or me, or both. All right. So here's one where maybe he's using one hand, he's smothering the person or pinning her down the other hand and stuff. And if he thought she was going to be alone, then that definitely could have been the plan. I certainly don't have any idea whether he intended to go in there and end up with the result he got, which was having to deal with 4 people. I did take his creepy survey before they took it off the internet, and it was really creepy. It was really weird, and I've walked through it, and the survey assumes you're a criminal, and it's your criminal who's entered somebody's premises, right? And it's probing what your mindset is and stuff like that. And it was anonymous. And as I kept going through it, you had to write answers to get through it. I gave some answers that I hope don't put me in court at some point. I did a survey a long time ago with the Chapel Hill Police Department for people who were victims of burglary. So we were on the victim side of it. And, we dealt with that very carefully, because it couldn't be anonymous because we were dealing with victims. So we knew when they reported a crime, but we also wanted them to be comfortable that they didn't have to participate, and the person talking to them wasn't another burglar planning to do it again. But his was coming from completely the other direction, which was, hey, criminals, tell me how it felt to do it. How did you plan to do it? How did you feel when you were doing it? How did you stalk the target? To do that in an anonymous survey. And why don't you go to prison and ask people that? Sometimes prisoners will talk to you. I just thought it was really weird. And there was a lot of stuff on Reddit like, oh, you can't get universities to prove stuff like that. I don't know. It turned out I think it was real. So there you go. So there's an indication of, did he track the victim for some time and built up the desire for the victim and stuff like that. And then this went worse than he had planned. And that comes back to something that we discussed on Eric Hunley's channel last Friday with Andrea Burkhart, talking about this case a little bit, because she's been able to go to some of the hearings, which is really awesome. Nothing like firsthand impression of the hearing to see what's going on. And I didn't really get into it there, except to talk about, they talked about his family's call to the grand jury for this other murder and stuff. And, oh my God, is he connected, or is he being unfairly maligned? I don't know. I wouldn't assume he was connected to another murder, because you shouldn't just assume that. But I'm going to tell you that it is highly reasonable to go with the odds that somebody who ends up breaking into somebody's house to commit an assault of that magnitude and murder them has done lesser crimes before that. At least the trajectory back when I was involved in this, that's a long time ago, but I don't know that criminals changed but so much. You would see a common pattern, not always, but it's a pattern, that there could be some peeping Tom type of activity going on. And that's why, we talked back then to police about not taking those crimes lightly, because sometimes people doing that, they're on a path to doing worse things. And then sometimes the person would break into somebody's house, and then finally it culminates and they enter the house while the person's in there, because they have to keep amping it up and getting closer to playing out the scene that they're imagining in their mind. So if he did this, and he did do it, then I wouldn't be surprised if he committed other crimes before, been in somebody's house where he shouldn't have been, and maybe watched people or stalked people or something like that. That would all be typical for the type. So whether it happened in Pennsylvania or Washington or somewhere else, I don't know. But I don't think he went from not wearing a seatbelt to doing this. That would be abnormal. Let's see what else we got. Thanks for making this easier to digest. It's interesting and complex. Yeah, it kind of is, I think. Although I think the state did a good job with their motion to boil the issue down. It's going to get more complicated as it goes along. Let's see. It seems like it was handled very carefully. Is that the general consensus? Well, I'll tell you what my consensus is of a party of one, which is that they were working as fast as they could, and the information developed reasonably quickly behind the scenes while they were under, if you recall it, enormous criticism from the public and lots of leads. When they put out the kind of vehicle there was and stuff, they get crushed with leads. Most, I'm sure, by well-meaning people, but a lot of workload there. So you don't want to arrest him too early and have an issue with that. And you also don't want somebody who's killed all these people out on the street potentially going to do something else. So I think their balance was pretty good there, because by the time they arrested him, again, I say the defense can attack the indictment. And I think I don't know how far that gets them, because there are ways to cure it if it has a flaw. The indictment is just, did the grand jury properly find that there was probable cause to have him stand trial, to arrest him and have him stand trial? And the answer is yes. I mean, even if they didn't have this level of evidence, yeah, there's a lot of evidence against this guy. It's crazy. So they were absolutely correct in having him stand trial for this. And doing some scrolling down. Do court document signatures require legibility? Never that I've seen, and I'm thankful for that. I know what my signature looks like over the course of the years, but I usually can't read what I write. So, all right, let's see. I'll have to watch it in rewind mode. I still question because he left it behind. Surely smart enough to understand leaving DNA. Yeah, I'm not sure that he knew that he left it until he was gone. Okay, that's something I think. I don't think he put the sheath down and said, well, I'll leave this here like as a calling card. I think he'd never anticipated dropping that any more than he, say, anticipated a glove coming off and leaving it there. I don't think he thought that was going to happen. So I think he is plenty smart, but this was a mistake. And that's why I say, I think, in my imagination, the struggle that the victims did put up, to the degree they could do it, probably caused enough of the confusion and the flailing around to the sheath. Maybe it fell out of a pocket that he put it into, or dropped it out of his hand, as somebody says. And then the body's on top of it, the comforter's on top of it. He probably doesn't even know he's lost possession of it, and he leaves. And now the victims have participated in solving this case. First time catching me live. First time catching you live then. So it works out for both of us. And some of these we already did. Yeah, rookie mistake. I mean, it's sometimes you drop things when you don't want to drop them. For one time, we found an ID card at the bus stop that the guy got on a bus to leave the scene of the crime and literally dropped his ID. So just sometimes luck's not on your side when you're a criminal. So I think the DA was concerned regarding random probability factor in law enforcement's original genealogy. During investigation, it wasn't random comparison in the database. Yeah, and that's a big issue here, because what the state is saying is, yeah, well, this isn't evidence that he's guilty. We're not even going to bring this in as evidence. This was investigating and following a tip. I mean, sometimes you hear about police will consult with like a psychic or something. They're looking for leads, and they're saying that that's what this is. We're doing good police work to find a lead. We would not bring this into court to show he's guilty, because what we did was the right thing, which was compare, well, a better sample, which was the garbage found at his parents' house, to find out that it was a high likelihood it was the father of the person who left the DNA at the scene. That's in the probable cause affidavit, not this family tree stuff. I think that's what I read in this motion. And then when they did get his DNA from the search warrant, that's when they made the direct comparison. So I think what you're saying is right, but the state is saying we're not presenting any of that as evidence. The evidence is his DNA against that of the crime scene. He has to tug at the snap on the sheath since he's not experienced knife murderer. He struggles with everything. If you did have it snapped in at the time, that could potentially be an issue, because these are a little bit hard to pop on and off. I don't, like, you wouldn't go into a house to shoot somebody and have your gun in a holster. I don't know if you're going to go in there to stab somebody, you would have it in a sheath, but it's just imagining. everybody does it the way that they choose to do. So this comparison is a relief, in my opinion. And I certainly think that. I mean, I was waiting to see, well, okay, is it high? It's a family tree. That's one thing. That could be, whatever. Then it's high odds it's its father that they got another sample from. And then they have the 1 in 5 octillion chances that it's somebody else. So that was awesome. Let's see. And people chatting with each other. So I'm scrolling through that. How many times did you daily unsheath knives to kill and murder? How practiced? Yeah, well, most people aren't going to do that too often. So, you get faster at things as you do it. So if it wasn't a sheath, there could definitely be some issues there. That's kind of up to us to imagine at this point. The main thing we know from watching this is that, or from reading this, is that the sheath was found underneath a murder victim and part of the bedding. So that's the critical point, how it got there. It's, interesting speculation for sure. Well, does this bombshell level evidence make it much more likely he'll plead guilty? Nah, I don't think so, because he already knew he did it, and he knew it was his DNA before it ever got out in public. So he knows all that. And like we've all said, he's not dumb, so he knows that. I don't know if they want to try and get the death penalty off the table, or if they're going to push the ball down the field further and push this closer to trial. But I mean, this dude did it, so I don't know what's wrong with him, but somebody of that kind of mindset is a danger forever. I don't even know what you're talking about here, but I'm going to read it because I like it. We've all seen enough Dateline to know better. Have you ever seen enough Dateline? Have you ever heard enough Keith Morrison? Well, it wasn't going to work out that way, was it? All right. I'm going to assume this was an emotional act, and it overrides the brain sometimes. It's a complex thinking process. I think these kind of murderers have. I'm sure there were a lot of emotions, but I also think that he had imagined a scenario in his mind quite carefully, probably run it over in his head hundreds of times. And then when he went through with it, it didn't go the way that he thought it was going to go. So part of the emotion could be, I gotta get this done and get out of here. He seems emotionless. He does when he's in court. And when you have evidence like this, particularly against him, then you could look at him and at every time and go, that dude is dark and cold. And that's one of the things his lawyers have complained about, that all the coverage says, look at this soulless killer. And, he blinked too much. He didn't blink enough and stuff like that. It's hard to not look at him if you think he's guilty with that in mind. He smiled at his lawyer, and then when he smiled at his lawyer, I'm like, I'd like to, that made me mad when he smiled at his lawyer, because, I don't like this guy. So he's kind of damned if he does and damned if he doesn't in that regard. I would just say this. I think his behavior has been certainly what his lawyer would hope it would be in court. He walks into the room. He doesn't do anything he shouldn't do. He looks like he's paying attention. He answers questions that are put to him by the judge when he's supposed to. He acts appropriately to his attorneys, and then he gets up and leaves when they ask him to. And that's all you want him to do at that point. So here's some more speculation on if there was a fight back and stuff like that, and what the potential struggles could be. He's too stoic. Man, I hope my DNA never shows up on anything. I'd probably, there's a lot of people who would put me in a chair if that's the standard. Not that he's not stoic, because he kind of is, but he hasn't gone downhill like Richard Allen has, right? And that was a creepy survey. Yeah, I was talking about that earlier, and you probably heard that, and maybe you made your comment then, but it was definitely creepy. Your lawyers coach you on how to behave. How can you say a thing like that? Of course they do, if they think they need to. At least we always did. So are they pushing for the death penalty? It's always interesting how trials are different when it's on the table. Well, it is on the table in this sense that the state technically has it, although they have that chemical thing going on that they don't have the right chemicals, but then they're trying to get the firing squad, and that ain't going to work. However, I think they have not declared it yet. They have a certain time frame in which they have to file paperwork saying we're going to do it or not do it. I don't think they've done it yet, or if they have, I missed it. I hope there are no glitches in any legal way for him to be granted a mistrial. I think he's guilty of sin. I think he is too. And I haven't seen any kind of glitch that would, certainly at this stage, that would warrant that. But what I have seen is the defense being extremely active and challenging all the things that the state is doing, and that's their job. And I respect it because it's a different mindset than what I have, because I think the guy killed 4 innocent people, stabbing young women to death like that. I would not want to be sitting next to him and trying to bring my A game to the court. But that's what he deserves, and that's why I never did that kind of work. Let's see. I hope Ann Taylor runs her DNA test on it. Well, yes, agree with that. So you should have access to the evidence. Let's see. Seems like they pulled out all the stops. Do a good job with the clock ticking. That's admirable. Well, you can bet they were working hard on it. A lot of these guys care a lot about solving these cases. A lot. Can I expound on my law enforcement involvement background? Yeah, I'm going to put that up as a potential topic. It's that or a couple other ones that would be too boring for the general public. But I have some interesting stuff there. I've worked on a lot of nasty cases around here when I was young, but I moved to a different type of practice after that. He's rolling around on the sheets and covers with a struggling body, hops up, etc. So you've got a clear picture in your mind of a scenario there, which I appreciate that I don't right now because I'm more thinking about this document. Kohberger wearing gloves to sort trash, take to his neighbor's trash bin, most likely means he knew they had his DNA from the sheath left behind the scene. Yeah, quite possibly, or at least he was certainly worried about it. At some point, I think he probably realized, oops, I don't have this sheath, and he gets rid of the knife somewhere and all that. But he's not probably up at 2 a.m. bagging trash into individual bags and sticking it over to his neighbor's garbage can for no reason, even though he was allegedly weird and wanted fresh pots and stuff like that. I did go back and read his social media posts for this mental condition that he had when he was younger that he talked about. And I don't doubt that he was sincere and that he did have a mental condition. That's not the same thing as being legally insane, of course, which is not going to help him anyway. I wonder when he discovered the sheath was missing, this comment says. Where's the last time I used it? Should I knock and see if I can come back and get it back? You know, what's interesting about that is there's a potential that his phone was in the area around the house the next day. I don't think that's exact or anything, but it would be wild if he was maybe driving back around there to see, did I leave this on the street? Can I grab it? You can say you don't want to do it, but they have a search warrant, so they're getting that DNA. Okay, that was creepy. So I said something creepy at some point. Sorry, I'm behind on the comments. So and then I say so many creepy things. It could be anything. Emotional act brings up the stalker assault ideas. That's why he's built this urge. Yeah, I think that's, it's a fantasy, a scene that he's developed in his mind. And he kind of, I think he's compulsive toward that. And the surveys, maybe some evidence of that in addition to it being his field of study. So, like I say, I went one way, which is talking to victims, and he wanted to hear how criminals did it. I wondered if he thought he was going to go back and get it as well. Yeah, okay, so I was starting to catch up with you. It was reported his car was back at the scene at 9 a.m. And I don't know if they know that for sure. You probably know better than I do, but I had heard the same thing. So let me change this a little bit. So let's see. Yeah, that's right. Okay, I don't want to skip that. I always wondered if he thought about, this is a comment, about going back to get it as well. It was reported his car was back at the scene at 9 a.m. in the morning. And then the next comment says, I paid close attention to the tracking at the 9 a.m. hour when he was nearby again. The police weren't there. I wondered how tempted he was. It's funny because if he had gone back in there and gotten that sheath and that's the only place they had DNA, it would have made the investigation a lot tougher and the case a lot tougher because people could reasonably say, well, just knowing about his phone and his car is not enough. But he didn't do it. So did my choice of law school shape early law job considerations? Not really. I mean, I did things before I went to law school that had a lot to do more with this criminal stuff than after I got out of law school. I did less of it. Let's see. I won't go too far into that background point at this point. I'm curious if he had many friends. Haven't seen or heard of any. Not that anyone would want to admit to it. I think they have talked to some, I guess, classmates, and maybe that's what it could count for a friend for him. And there's the rumors about what his sister said and stuff like that. His personality, it sounds like, has been off for a long time, and that's not surprising if he's the guy who did this. And he had his own mental issues and things like that. Let's see. Oh, the creepy thing was the Keith Morrison voice. Well, I didn't get to practice it. So, I mean, my wife and I are always going around doing Keith Morrison to each other about things happening just regularly around the house, but I wasn't ready. So let's see any more Star and Treat stuff here. I don't know if I fired that one up. Another member there. It's interesting. It shows that YouTube's an interesting experience. So that's what I know about this motion for protective order. And let's see, this was June 16th at 3:28. And it's a snippet of, a bombshell snippet of information in there in terms of where the sheath was and how it was found. And then the match of the DNA. It's just not surprising, but it is big. And I'm glad to see it in black and white, because this case has had a lot of speculation to it that is absolutely pointless. Not as bad as the Delphi case, but still. And so that's it. So we have a DNA found on the container of the murder weapon at the scene of the crime. And then we have the poll that many people have voted on about what if the murder weapon's found at the scene of the crime. So we will talk about this on Friday, and whether the DNA on the sheath is direct evidence or circumstantial evidence of his guilt in this case. And would it matter whether it was also on the knife if they found it? Would that be different or not? And I've seen a lot of people comment on that poll with very good thinking. And while you may not come up to the correct law conclusion, that's okay, because the thought process is good. And I will read during that weekly docket some general jury instructions that tell you that it can be circumstantial evidence, it can be direct evidence. How much weight you give, that's up to you as the juror. So one's not better than the other, and I think that's important to know. And I don't see any more questions about this, as this was pretty clear, right? But it's big. And, you see a case like this and you want it solved. You don't want the wrong guy staying in trial, and you don't want somebody who's killing people like that out there. And you don't want the family having to deal with such a lengthy investigation process that it drags on for years like these things sometimes do. So you have to appreciate that law enforcement was able to bring an arrest so quickly, but you also have to appreciate the piece of physical evidence that was found there. And in my mind, I know we've talked a lot about a lot of scenarios of how that sheath got there. I'm going to imagine right now that it happened because of the victim struggling with him and that they helped solve their case. And I don't know it, but that's how I want to think about it. So thanks for coming by this impromptu live stream in the evening. And hopefully I'll see you guys on Friday, and we'll talk about some things then. Now I'm going to fire up this new outro here that I'll use for certain kinds of cases. All right, thanks guys, and good night.